election code under 11113. So it is not a question of, and just like in Hassan, where the qualification issue is a constitutional one, and particularly for federal offices, right, those constitutional qualifications are by definition not set by the state, they're set by our federal constitution under U.S. term limits. That is what they are. And so those proceedings occur under 113, and in Kuhn, and as the Secretary's brief in this case, where a issue is the qualification, you can public purpose or for public ends. So for more than just your purpose, right? If you're going after a particular judge for dissatisfaction, but it is a public in that we're advocating on behalf of the public using this violence for a public end, just like we saw in January.
Let me stretch my hypothetical. Say the person is expressing concern the judge is too liberal or too conservative. Public expression. I don't like the judge's politics, so I'm going to take that action.
That would not be for public purpose or public ends under this definition. It really requires, as we saw here, and as the testimony of Professor Magliocca at trial talked about the historical understanding of insurrection, that there has to be a real public use of force to hinder or prevent the execution of the Constitution of the United States. And here, there can be no doubt that trying to disrupt the peaceful transfer of power by stopping the counting of the electoral votes is hindering the execution of the Constitution.
The distinction then is that there's an attack on the authority of the government, even if it's not an effort necessarily to overthrow the government. Is that what I hear you saying?
Yes, because an effort here to delay, use violence to delay the count would be an insurrection.
And I know you want to save time, but just very summarily, do you see much distance, if any, between the argument that you're making that the district court adopted and the argument that is set forth in the Bode-Paulson article? Is that, I mean, they use slightly different words, but they seem to sort of deliver a very similar message in my estimation. Is that fair?
That is fair, but I think what is crystal clear is that what happened on January 6th easily satisfies either definition.
So let's not get lost in the weeds on the test.
Let's not get lost in the weeds. And I do want to save time for about, I want to make sure I answer the court's questions as well, but if I could end on a final comment and then come back for rebuttal, which is that our Constitution, as we talked about, is just a document. It's a promise to each other that we must enforce to protect our shared democracy. And committing ourselves to that Constitution, the rule of law, comes with real fragility. Because our Constitution commands no armies, has no police force. All it has is very limited self-defense mechanisms that my colleague mentioned. And that is Section 3. And all Section 3 says that if you take an oath to support the Constitution and then turn around and attack the Constitution, you cannot be trusted to take an oath a second time, because you've shown yourself unworthy and incapable of ensuring that we remain a nation ruled by law rather than by one man. Qualifications, by their very definition, limit who can vote or who can run for office. And Trump's argument that because he's popular, that should affect how we interpret Section 3 here could not be more dangerous. Jefferson Davis would have gotten a lot of popular support right after the Civil War. And the application of Section 3 is at its most urgent when a person who has desecrated their oath to the Constitution already seeks to become our commander-in-chief again. If we say that this conduct by this person is not enough under the Constitution, what we do is empower Trump and others to use more political violence to attack our democracy. Enforcing our Constitution enables the will of the people, and we must enforce it against unlikely candidates like Hassan and popular candidates like Trump. I reserve the rest of my time for rebuttal, but we ask that you reverse the district court's finding that Section 3 does not apply to Trump and affirm in all other respects.
Mr. Olson, before you sit, I have a question. The grounds for disqualification here obviously have to do with Section 3. And I worry about the fact that Section 3 itself doesn't have an enforcement mechanism. And so here you're saying, well, Colorado state law allows us to enforce it in a way. And you said California has a system. Do we want an approach where each state decides on their own what Section 3 means or how it should apply? And then those states that don't have a law like Colorado are not able to do anything about it. I worry about that. Can you address that concern?
Sure, Justice Moore. I would build on my answer, I think, to Justice Birkencotter earlier. And if I may, a couple minutes for rebuttal, even if it takes a little longer, Justice Boatwright. I think I'd focus on two things, which is particularly for the presidency, where Article 2 gives sweeping authority, as the Supreme Court just said in Shuffalo and Baca a couple of years ago, for states to determine how to do it. There is going to be some uncertainty. Some states used to use legislators to pick their presidential electors instead of a popular vote. So some uncertainty is built into the system. And then I would say the second piece is that the legal standards that apply here under the Supremacy Clause, or what engage in insurrection means, will be uniform. It may take a little bit to get there, but there is a mechanism to ensure that uniformity. And so there's no need to worry that there's going to be 50 different approaches to this issue. There's going to be one approach here. Maybe another state will do it, maybe they won't. But there's not an overwhelming indication that there's going to be 50 different approaches here. And the last thing I would say is, even if that was the case, that's the nature of a federal system like we have. The states have broad authority, particularly where there's a specific allocation of responsibility under the Constitution. In our existing mechanisms, the courts, the Congress, the U.S. Supreme Court have shown their ability to keep those concerns from overwhelming the issue. So that's what I would say to that question.
You may reserve the remainder of your time.
Thank you.
Thank you, Mr. Olson. Mr. Gibson, when you're ready. That was a very steady pour. Impressive.
I'm going to need that water, I think, Your Honor. Members of the court, thank you very much for your attention here today. Again, my name is Scott Gusso, representing President Trump in this matter. Time permitting, this is a big case. I'll try to talk about why this court should not exercise jurisdiction under 113 and 1204 under the principles set forth in Frazier versus Williams and Kuhn versus Williams. I'd like to talk about the textual structure, the officer of the United States, the office under the United States, and the oath, the textual structure. And time permitting, I'd like to talk about the issue, the legal standard of engagement, and of course, insurrection as well that have been asked, and then perhaps get to the infirmities of the court using the January 6th report. I know there's a lot. Please feel free to interrupt me and move from one section as members of the court see
Just
fit.
before you dive in, I did not hear political question doctrine on that list, so.
I
is that
put
by-
that under the category of enforcement,
Okay.
here,
Thank you.
broader federal enforcement. So we sort of view, when you talk about self-execution, preemption, political question, they are sort of intertwined with some of the same considerations, in part because of the difficulties of applying consistent standards, which ties into the fact that Section 5 of the 14th Amendment creates a specific enforcement authority to Congress, which was recognized in the Griffin's case here. So that does sort of talk about the justiciability. I can dive into that section if
Let's
you want
start
right now.
there.
I'm sorry?
Let's start there.
Okay. Your Honor, so enforcement is the proper framework, and this is a non-justiciable question, and there are prudential concerns that 3,000 different state jurisdictions will approach this in different ways. Now, I understand that the petitioners have said, well, that's okay. Under Article 2 powers, states can do whatever they want. Well, that's not true. States can't do whatever they want under the Article 2 powers. There are still nonetheless constitutional mandates. For example, in petitions, states have to behave a certain way, as in Anderson versus Celebrezzi. for presidential candidates. And in fact, in Anderson versus Celebrezzi, the court said that the state interests are lessened when it comes to a presidential candidate. An invocation of Article 2 powers to choose presidential electors, that's not an enforcement mechanism in the sense of a judicial enforcement following a law. It's a political process, and it's a value decision. The people of the state of Colorado could, for example, if they amended Section 20 of the Schedule Constitution, that requires allocation of electors by popular vote. But if they amended that, they could say, we don't want anyone with gray hair. We don't want anyone over 5'2". Okay, they can create those through political value decisions. That's not an enforcement mechanism of Section 3.
Well, let me just ask you directly about that to go right to the point. Obviously, you focus on Section 5, and it says, it gives authority to Congress to enforce the 14th Amendment. It doesn't say exclusive authority, but my concern is this. If we have to rely on that as the enforcement mechanism and the 14th Amendment is not self-executing, then the Due Process Clause and the Equal Protection Clause are not self-executing. So Congress could nullify both of those by doing nothing and taking no action. That's concerning. The 13th Amendment has the same language. I don't think anyone would say that Congress needs to act to enforce the abolition of slavery. So help me understand how do we get to self-executing here?
So I think Justice Chase would disagree with that characterization with respect to the consequences. In the Griffin's case, which I think was discussed at length in Professor Tillman's amicus brief, Justice Chase basically created sort of the sword versus shield distinction, that in the Jefferson Davis case. And in the Griffin's case, he said that, I think he did use the word executing, that the Section 3 does not execute itself. In fact, it requires implementing legislation. Now, that was from a Chief Justice of the U.S. Supreme Court. I recognize he was riding circuit in Virginia. But Congress then almost immediately did what he suggested or what he demanded to be done. In other words, it passed the Enforcement Act. That's consistent.
Sorry to interrupt, Mr. Gessler. To come back, I guess, to Justice Gabriel's question, the fact that Congress passed one form of enforcement legislation doesn't mean that there might not be other ways that that Section 3 comes into play. They didn't cover the field.
Well, that's fair standing on its own. But in response, we still have Justice Chase's decision in the Griffin's case. And remember, Justice Chase took a very muscular view of use of the 14th Amendment. He dissented in the slaughterhouse cases and specifically decried the limitation of the privileges and immunities portion of Amendment 14. So, but when you look at Section 5 of the 14th Amendment, why do we even need that? Well, Congress thought we needed it. Congress thought the framers thought we needed it. They thought they needed it in order to grant Congress that authority. They didn't grant the states authority. Now, one can say, well, that means nothing. But actually, if you look at the 14th Amendment, the whole purpose of the 14th Amendment was to limit states' authority. It would be very counterintuitive otherwise. Yes, ma'am.
Yeah, so can you point us, though, to sort of that, the textually demonstrative constitutional commitment? I think, as I understand your argument, you're sort of asking us to look at the gestalt, right? You want us to look at the whole, these four separate parts of the Constitution, and sort of stitch them together and say, look at that in terms of this first prong of Baker. And is that correct? Can you point me to something specific?
So with respect to the four prongs of the Constitution, you're referring to?
Your argument with respect to how this is, how we are foreclosed under the political question doctrine. Sorry, I'm pivoting around here.
No problem. Well, I think there's a couple reasons. One is the prudential reason that had been discussed, which is a multiplicity of different states. The petitioners mentioned that California is a post-election opportunity for attack. So that may be one way. New Hampshire has said that despite the Hassan case, they had the exact same situation as in Colorado. They don't have the authority. So you do have a patchwork where voters are going to be treated differently and affected across the country. And that is somewhat chaotic.
Isn't part of the answer to that if we were to say that President Trump can't be on the ballot here, there's a very high probability that the United States Supreme Court would step in and decide what the standards should be, one would think, so there wouldn't be the same potential for the chaos that you're describing. Is that not a fair response?
Well, President Trump would certainly think that, yes, we would want to appeal it. But I don't think that the court should rely upon the hope that the U.S. Supreme Court will step in. The standard is we should look at that in advance and prevent that bad situation from occurring in the first place. Those are the prudential concerns.
But let me pick up on, and really the point you made, which was we have this today. We haven't had chaos in well over 200 years. I mean, states have these authorities. California has one mechanism, New Hampshire has a different one. I'm not so sure that we have the crisis that you might suggest.
Those mechanisms are procedures. They're not the substantive application of Section 3. There is a difference there. When we talk about procedures, yes, New Hampshire has a different set of laws for qualification than Colorado. But those are all different procedures. They're not the substantive application of a disqualification standard.
Forgive me, Mr. Justice, let me ask you about that. So can the Secretary of State disqualify a candidate who is not born in the United States?
That's a question. I don't think there's a statutory authority for them to do that. Now the petitioner has said, well, Hillary Rudy testified to this and that, and deep respect for her, but that doesn't define what a state's authority is. We have 1204, which requires a statement of intent. And the question is the form for 1204, does that carry the force of law? That's really sort of the question.
Well, it's a constitutional qualification. That's why I was asking the question. I mean, there's some suggestion that we should look at different qualifications differently. The 35-year age limit and the born in the United States are one thing, but the 14th Amendment is something different. That's what I was asking.
Right. First of all, I'd say the 14th Amendment is not a qualification. It is a disqualification. And in fact, if we even look back to McKee's original introduction of that legislation, that talked about qualification and holding, whereas Section 3 only talks about holding. So I would probably not concede the point on qualifications.
So actually, to that, and I know we're going back and forth between political question and I suppose the question of whether Section 3 is self-executing. But as you say, it's a disqualification. The only thing that the 14th Amendment says that Congress can do is remove the disqualification. Doesn't that suggest that the disqualification attaches independent of any act of Congress? Otherwise, they'd have nothing to remove. Did they have to say that Jefferson Davis met the definition of an insurrectionist under the 14th Amendment?
I would disagree that Section 3, that last clause, can't be read in isolation from Section 5 enabling legislation. And the Section 3 congressional action is more akin to the powers of a presidential pardon. It's essentially a pardon mechanism. And I don't think one can draw the inference that forecloses or affects the substantive law that allows that disability to come into effect. You look quizzical, Your Honor.
I am in fact quizzical. Go ahead.
May I jump in?
Yeah.
Justice Gabriel, where are you going?
Go ahead.
So you mentioned these prudential considerations and, let's avoid chaos. One of the counter arguments is that by failing to resolve this issue on the merits now, we create the potential for chaos in January of 2025. And so there's much emphasis on this in the scholarly literature about how it may be better for us to try to resolve it sooner rather than leave the potential for a constitutional crisis after the next presidential election. What's your response to that?
The response is not if we follow what I call the rule of democracy, what Attorney General Stanbury said in a couple instances, that when there's uncertainty, the disqualification doesn't apply. Ultimately, if the Republican Party chooses to take that risk, and Republican and unaffiliated voters in the state of Colorado choose to make that choice, that is their choice. It should not be foreclosed from this court.
Well, what do we do about Timmons then? What do we do about Timmons, where the U.S. Supreme Court says there's no absolute right to put someone who's not qualified on the ballot?
I would.
And we're talking about a political party here.
Right. And I agree that there aren't absolute rights, but there's certainly a minimum in ambiguity here. We don't think so with respect to our approach But the Timmons and the Wisconsin Xrella Follett cases nonetheless stand for political party First Amendment rights. That even if state law, for example, in the Wisconsin case, even if state law mandates one thing on how to assign.
Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is a low, you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is a low, you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is a low, you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now.
chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths, or they could choose both of them. They chose one and one only, the one that did not include.
The one that covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law defining the two.
So
What
can
my
you make
point-
the argument that an oath to support is stronger than an oath to preserve, protect, and defend? the
Yes.
Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things, as
Like
shown.
preserve, protect, and defend.
It can mean that, but it can mean other things, or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the logical consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
Now, my argument is this. My argument is that the drafters chose specific, and the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate things. But the drafters of the 14th Amendment made a choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency, by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude
Why?
by choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers. And they did not choose the Article 2, which applies to the president.
And I guess I found, I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis.
I would
or
suggest
someone.
that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think that the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era. And it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this were does design, would prevent anyone from in that situation from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, can that be an insurrection? Or is that democratic choice? Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an
I don't
opportunity to vote for that person.
Go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different. And if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, look, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
But the rule of democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, I mean, the argument, if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution. And there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used to satisfy the conditions of Section 3, you have to be an office under the United States. You have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3 though for a second and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. The officer of the United States is used 4 times in the structural Constitution. And each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not gonna, I want to let you use your time the way you want to use your time.
So I feel like
Please feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse. And so the counter argument to that is that we have to look at context, and they assert that the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, this isn't a case, the incitement, and obviously we contest that incitement is part of Engage. Happy to address that as well. But this isn't an instance of sort of joint planning or a joint agreement where President Trump had specific conversations of back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th. That's really what you have to look at. And if you look at January 6th, his speech said, go peacefully and patriotically. He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Oh, okay, go for it.
And what he said is, he talked about that he was unhappy with what happened on January 6th. And people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was that use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on, those various iterations are used commonly throughout political discourse.
Okay.
So,
I'm sorry, finish your thought and then I'll jump in.
so the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent. And if other politicians, and we included, senators and President Biden uses the term fight like hell, it's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said intent and an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying stay peaceful. And he made a video that said be peaceful and go home. Now,
I want to let you keep going.
now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said be peaceful. But the objective language is saying be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I struggle with as I try to evaluate this particular piece of it. And that is that are we not dealing with clear error review of the trial court's factual findings about those circumstances? And I realize from your perspective, a lot of those findings were predicated on a report that never should have come into evidence. But setting that to the side for one moment, aren't we to a large extent stuck with the trial court's findings findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application. So I'm sort of throwing multiple issues in here, but I don't know that we are in a position to say that there was clear error with respect to her findings of his intent and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things in January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminent standard. And that is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all.
although the trial court did, right? I mean, she found specific.
And it's clear error for her doing that.
Okay.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets, public speech, public videos. And we don't contest any of that, what President Trump said in the evidence that was presented at trial. So I think this court doesn't need to look at the clear error because look, it's not just engagement, insurrection. And let me just talk a moment about insurrection. Justice Gabriel, I think a couple of folks brought up the different definitions. We have a consistent definition. I think you did as well, Justice. Look, the proponents of liability for Trump used
Not liability. You said liability for Trump?
or that Trump should be disqualified. The proponents.
But we're not, again, this isn't a Section 3 claim where there's any kind of liability.
Yeah, I misspoke. You're right. There's 2, 4, 6, 7 different definitions. The petitioners in their complaint, I'm not going to spend time unless you want me to read each one of these, but the petitioners in their complaint advocated one standard. Professor Magliocca advocated a different standard. The court adopted yet a different standard. Bowden-Paulson have had yet a fourth standard. Professor Graber provided a fifth standard. The cited Judge John Kane's grand jury charge, which we don't think has much force, but it has yet another standard. And the Simon Greenleaf treatise that was relied upon has yet another standard. Those are all different standards, two of which have been propounded by the petitioners themselves. Now, the petitioners say, it doesn't matter. They all include President Trump. They all include him. But I would suggest that the fact that the actual proponents of this proposition have themselves identified 7 separate and distinct standards, some of which require a public use of force, some of which don't, some of which require a hindrance, some of which don't, some of which apply to the Constitution, execution of the Constitution, some of which don't and apply to the execution of a law.
Why don't you focus, because your time is limited, on the one the district court adopted? Any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, if you look at historically in the context of how insurrection was used, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where's all that coming from? Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where they came from.
I would urge you, I think probably the best exposition of that was the state attorney general's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gessler, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
yes.
I just want to jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection. Why is that not true?
Well, I think what you're sort of saying is the famous quote. I don't know a definition of it, but I know it when I see it. That we don't have a workable standard, but we think in this instance it doesn't feel good, and it just seems.
Well, it's more than it doesn't feel good. For purposes of this case, what we need to do is figure out whether what happened on January 6th, one of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times and all circumstances.
I think most common sense thinking folk would look at it and say, you have sedition at one end of the spectrum, and you have levying war is the term that you've used, civil war maybe at the other end, but in between we have these things, insurrection, rebellion. I think we'd agree that insurrection is typically something less than rebellion.
And I would agree with that in the case, and some of the authorities support it, but it's more than a riot. It's more than a 3-hour riot on one building.
Was that just a riot on January 6th?
I only think it properly characterized that way and not as insurrection. And remember, look, the Constitution, Section 3 says engage in insurrection. It doesn't say in an insurrection. What's the significance of that? I think that it indicates sort of a broader process rather than a singular limited in scope event. And if you look at the Civil War, that was a broad four-year
That was
activity.
actually more than an insurrection, wasn't it? The Civil War.
Yes.
I believe levying war was insurrection is getting at something less than
a war.
Likely, yes. Now, there are lots of instances in the ratification debates and the framing debates, and I think the AG's pointed this out in their memo, that insurrection, rebellion, war, treason are oftentimes used interchangeably by the drafters. And in fact, you look at some of the authorities here, the petitioners cite, they'll shift from insurrection in some instances and draw examples from treason or rebellion. So they are used very interchangeably. So we would argue that sort of on the scale of violence and duration and scope and organization, the events of January 6th were more like a riot and far less than a rebellion. And insurrection is far closer to rebellion than it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it, and that's in part why this is a non-justiciable question. But to the extent you push me, which you are, I would say it requires at least multiple considerations that go beyond what we had here. I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you said, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't, it was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government. The goal, as if one assumes the predicate that President Trump directed the crowd, which we reject, to get Mike Pence, Vice President Pence, to delay the certification. That's not nullification. And I understand it's violent, and I understand it's bad, but we, as I would submit, as lawyers in this process, need to distinguish those gradations because they have meaning. And what I would say is the goals were not as broad as something like the Shays Rebellion or Whiskey Rebellion. The organization, there was very little evidence of a robust command and control structure and that level of organization. The use of force did not involve arms, certainly not the level of arms necessary to overcome.
Let me just jump in there, Mr.
And it wasn't capable of being rebellion. Yes, sir.
The arms, I mean, you make a legitimate point about, there not being a lot of evidence of arms being taken to the Capitol on January 6th, but there were a lot of makeshift weapons that did a lot of damage. I think at least the petitioners are saying 170 people were injured. That's a lot of violence, right? You'd agree. And irrespective of whether people brought guns and knives to the event, I don't know that we need to, pause too much about that when we have that level of violence. What am I missing?
What you're missing is a riot is consistent with using flagpoles and broken up bike racks as weaponry. An insurrection or rebellion is organized, deadly force that's going to nullify government authority. I think there's a big difference there. And look, I understand that the violence of the Capitol was not acceptable, but I do think that it is our job to apply legal standards and understand the gradations involved and whether or not this truly rises to the level of insurrection.
Well, why don't you talk about engagement? You've only got 3 minutes and 40 seconds. So, and I'll just ask you a question to help move this along, hopefully. My concern, I guess, would be, I understand what the argument you make. Engage doesn't mean incite. Those are different things. A leader of an insurrection usually is not involved in, or frequently is not involved in the hand-to-hand fighting. They direct it, they organize it, and then they stand back and they watch it. That would be engagement, I would think, if you had an actual insurrection. So help me understand what engage means.
Well, I think that does. And what that requires is sort of a two-way conversation. Hey, you sergeant or lieutenant, I'm the general. I'm going to do this, you're going to do that. That's different than public speeches. Now look, I mean, if there were a public speech and someone said, oh, and made an agreement with the other side and say, when I say during my public speech, the eagle has landed, then we take action. I would submit that that's engage, but that's a much different instance than incite here. Incite is to sort of arouse these emotions only through public speech. It's a one-way conversation.
So if a leader did a more direct, I want you, and let's make this hypothetical. A leader said, President, I want you to go to the Capitol and I want you to take it over and I want you to ensure that they do not go forward on the Electoral College and use violence if need be. That would be engagement even if the leader doesn't go with them?
Very likely, yes.
Okay.
Very likely, yes. If there is an understanding, an agreement, and not some broad inferential conditioning that Professor Simi testified, I don't think that meets the legal standard. But there has to be very definite sort of meeting of the minds that that's in fact going to happen for it to be engagement. Now, it could still be incitement because it's a direct call for violence, which did not happen here. But there is a difference between the two. They do describe. And I would point out that Congress has treated it as distinct. You know, you look at the Second Confiscation Act in 18 U.S.C. 2383, it says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection. So they treat it as differently. And by the way, if I may say, at the end they say, incitement, sets on foot, assists, they shall be incapable of holding any office under the United States, which indicates that the presidency cannot be barred by mere statutes of Congress. So that's that language, under the United States again. Consistent usage and pattern of that. Let me just sort of end up in my wrap up in the last minute here. This was constitutional litigation. Had the shoe been on the other foot, had the secretary taken action, and President Trump would have been required to file a lawsuit. That would be constitutional litigation as well. And all of the dangers and infirmities that Frazier warned about, that Kuhn recognized, that happened here. This was an inappropriate forum for this. It should have been a declaratory judgment action. They could have fought out the standing issues, and we would have done that appropriately. And that's a pattern that has been followed in Colorado in the past. With that said, if you look at the text and the direct textual application of Section 3, it doesn't mention the president. And every structural piece that we've discussed, the natural and comfortable meaning points towards the president's exclusion. That fits in with the broader fact that it's not enforceable by state courts against a federal official. The court should not have engaged in insurrection. Certainly the January 6th report was deficient. We ask this court affirm the district court below, but also strike the dicta from the decisions beyond that court's jurisdiction. Thank you very much.
Thank you, Mr. Kessler. Mr. Olson, you got about 3 minutes, 46 seconds.
Thank you, Mr. Chief Justice. In short, Trump claims this case is too hard for courts to decide, that the standards of insurrection can't be determined, but that's exactly what the district court did below. And to the extent there's a dispute between courts that reach these questions, our country has a well-worn mechanism for addressing those inconsistencies. I want to talk briefly about insurrection, the officer, and then end on the Colorado Election Code. Justice Hood, you asked how far context goes. It does a great deal of work. In Claver and Hardware, this court said, or the U.S. Supreme Court, Justice Stevens said very explicitly that evidence of authorization of wrongful conduct in other circumstances was relevant to whether the speech at issue there was within or outside the First Amendment. And because there was no other authorization, no other evidence, they found the speech protected by the First Amendment. Here, the district court made extensive findings that the speech by President Trump
Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now. Given the unprecedented millions of Biden illegal aliens who are invading our country, it is only common sense that when I'm reelected, we will begin, and we have no choice, the largest deportation operation in American history. We have no choice. On my first day back in the White House, I will terminate every open borders policy of the Biden administration. And I will invoke the Alien Enemies Act to remove all known or suspected gang members, drug dealers, or cartel members from the United States, ending the scourge of illegal alien gang violence once and for all. Joe Biden and the Democrat Party are incapable of solving any problem. There's not a problem they've been able to solve. Crooked Joe is you know this. Did you ever hear this? Crooked Joe is a low IQ individual. And he is truly the worst, most incompetent, and most corrupt president in the history of our country. In fact, Jimmy Carter is very happy because he looks like that was a brilliant administration by comparison to what you have right now.